All right, let's go ahead. Okay, let's go ahead and call to order the meeting of Templeton Community Services District Board of Directors. Roll call, please.
Directors Fardanish.
Here.
Giardini.
Here.
Logan.
Here.
Pearson. Here. And Peterson.
Here. Let's please stand for a pledge of allegiance.
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Order of business, we only have one item on there, so I'm assuming nobody wants to change the order. Public comment, members of the public may address the board on any items of interest within the subject matter jurisdiction of the board, but not on the agenda today. In compliance with the Brown Act, the board cannot discuss or act on the items not on the agenda. Any public comments? No, okay, very good. Consent agenda, we have two items on there, the minutes, the board will consider the adoption of regular meeting minutes of April 2nd, 2024, and the treasurer's report. The board will consider approving the February 2024 treasurer's report. Any board member wants to pull any items for discussion? No? Okay, no public, okay. I just want to make a quick comment. Treasurer's report, as always, they're great. Appreciate it. You do a lot of hard work on that, and so thank you so much for that. All right, if nobody wants to pull any items, I'll entertain a motion to approve those two items.
I'll make a motion that the board approve the consent agenda items A, the minutes of the April 2nd, 2024 meeting, and item B, the treasurer's report for the period ending February 2024.
Yeah, do I have a second?
I'll second.
Okay. Roll call.
Directors Logan.
Aye.
Pearson.
Aye.
Giardini.
Yes.
Peterson.
Yes.
And Fardanish.
Aye. Great, the motion passes 5-0. Thank you. Business item. So we have a discussion item. This is for a discussion only. We have our legal counsel, Josh Horowitz, on Zoom with us tonight. Thank you for coming. Thank you for being here. Appreciate it.
Sure, happy to be here.
So we are going to discuss the role of board, staff and legal counsel in district governance, operations, and interactions with the public. So did you want to start?
No, Josh Wars prepared a presentation on this topic, and he's prepared to walk you through that, answer questions that you might have on subjects that are related.
All right, Josh, the floor is yours.
Thank you, Mr. President, and good evening, everybody. Thanks for the opportunity to speak with you this evening. This presentation came about in discussions with General Manager Briltz. He advised me that there were some concerns by a couple of the directors, Director Giardini and Pearson, about the district code provisions for ADU connections originally, and later a related allegation regarding the roles of various folks at the district about giving legal advice and whether the general manager was engaged in any unauthorized practice of law. And those discussions with Mr. Briltz, part of this also arose because there was a discussion about the ADU issue at a board meeting that became quite extended, and it ultimately resulted in a potential Brown Act violation that I advised the board on earlier. And then just given that series of events and the questions and concerns raised by the directors and the board generally, I thought it would be helpful to present some advice and a presentation on the roles and responsibilities of the board, the general manager, and legal counsel. And I understand from Mr. Briltz that the board hasn't had any recent board training So it seemed like this was a good juncture to actually go ahead and have this discussion. So I will proceed and just ask at this point that the board holds its questions until the presentation is concluded, and then I'm happy to answer questions and engage in any discussion with the board on the issues that are going to be presented here. And with that, I'd ask to go to the next slide, please. So I'd like to start these kinds of presentations with a classic quote from Henry Clay. It kind of summarizes in a very succinct way the general principles underlying board and staff service, which is basically to serve the entire public that's served by the Templeton Community Services District, and to do that in a trustworthy and open manner. In discussing Mr. Clay's quote, what it really gets to is that I intend to kind of drill down from that quote to the details of what the board's general managers and council's roles are and what they involve in terms of ensuring delivery of Templeton's services in a fair and transparent manner, and to, talk about this in a practical sense. Next slide, please. So here we have a slide that just talks about the definition of governance. I like to contrast the dictionary definition, which is kind of passive, and contrast that with the active definition as it applies to local agency governance. And obviously, in this context, governance means that the board acting collectively to adopt and oversee the impartial implementation and administration of policies that promote and protect the best interests of the entire community served by the agency. And this definition also pretty much scopes out and defines the board's general authority and role in running the district. Next slide, please. And a companion definition slide here is what is public service? And again, we've got the dictionary definition, and then the more colloquial and practical definition that public service involves citizens like yourselves who are willing to volunteer their time to improve their community and promote its well-being and interests at large and without regard to personal interest or gain. And I think those principles are really important to keep in mind. This is what governance involves. It's public service, and it's an outward-looking activity. You're here to serve others in a selfless manner with an open attitude and with an intent to provide your constituency with a high level of service and to solve the problems that confront the agency and the community. Next slide, please. So want to get more into the detailed discussion of the board of directors role, since you are essentially, as the slide says, the captain of the ship. You provide the overall policy direction and oversight of everything the district and its staff does. And that's an internal issue. And then there's the external issue of you are the standard bearer for the district. You are the chief advocates of the district's policies outside the organization as well as within it. And, it's important to keep in mind, directors are elected by and directly responsible to the district's voters and ratepayers, so the buck stops with you. Your role, again, is to provide leadership, oversight, and financial supervision in all of the district's mission areas. And I'd like to always present to community services districts this quotation from Government Code Section 61040C, because this really kind of encapsulates what you're here for. And it's a key concept in your governance obligations. You're here to look after the district and its ratepayers as a whole without being beholden to any special interests. And, you know, that sounds very, like a very definite statement, but it doesn't mean that in coming into the boardroom that you have to leave your knowledge, experience, and personal outlook at the door of the boardroom. What it means is you have to govern fairly and flexibly, but you do it within the context of your background and experience, which helps enrich your discussion and policy making and ultimately guidance of the district. Next slide, please. So this lists out some of the key responsibilities of the board. Obviously, it's about the district's mission. You're here to provide policymaking and oversight, ensure that the district is properly operated by your staff, that it has sufficient financial resources, and you have the right accountability systems in place. You also have several key employees that are directly responsible and report to you, being the general manager, the treasurer, secretary, legal counsel, and the auditor. And, you know, and in thinking about these responsibilities, remember that, you know, and I'm stating the obvious, you probably all know this, but you are a community services district. You are governed by a set of statutes in the government code 61,000 and following, called the Community Services District Law. And that defines the scope of your mission and your particular duties and responsibilities. Next slide, please. So this slide talks about effective board conduct and lists out some of the ways that the board can implement that conduct and ensure appropriate operation of the district. It's about vision, it's about collaborative and open processes, acting with objectivity and honesty, and inviting all constituencies to come in and provide their points of view and to process those and to come up with a set of policies that best serve your constituency, and to do that in an open and public manner. And, you know, the essence of this list is really what makes a board effective is having a clear vision of the agency's mission, having a collaborative and respectful style among the board and in your interactions with staff, ratepayers, and other communities of interest, a can-do, transparent style that invites public input and participation, and of course, following your own policies and your legal obligations under the Community Services District law and other laws that govern the district. Next slide, please. A related slide talking about board conduct standards. And here we have Abraham Lincoln, who kind of encapsulates a concept. You know, you need to exercise your power and authority with fairness and with attention to the district's mission, and to do that free of other loyalties and any personal advantage. These conduct standards are what make an effective board possible, and by internalizing and complying with these standards, you help ensure that the board is perceived as working in the ratepayers' best interests. And also following these standards builds trust with staff and your internal and external constituencies. It enhances staff morale, helps you work with your public and convince them to go along when the hard decisions come, and to create a common sense of district's missions and goals. Next slide, please. And this slide talks about the results of proper board conduct. I touched on that in the previous slide, but by being perceived as operating the district and governing it with appropriate leadership and openness and respect for the rules, what you do is also help ensure that the public respects the board and the district's mission, and most of all establishes you as leaders. And you also model that leadership for your staff and others in the community. And as I said previously, by doing this, you also get buy-in for changes, new programs, and the difficult decisions. For example, when you have to go out for a rate increase or whatever, if your constituents trust you, they're more likely to go along with your proposals for increases in rates, as one example. And as the last bullet point says, all of this promotes the confidence of everybody internally and externally that the board's doing the right thing. Next slide, please. So moving on to the general manager's roles and duties. As we've discussed, under the Community Services District law, the board directs the GM, but after the GM, the buck essentially stops at the staff level with him as far as the board's concerned. Under Government Code Section 61051, the general manager has broad authority to essentially operate the district under the board's oversight. And that means overseeing the district's day-to-day operations, the employment system, consistent with the budget that you approve, to fix and alter the compensation of employees and to expend funds on district programs, construction of infrastructure, etc. And all these bullet points, except the last one, are actually prescribed in section 61051. This last one, this last bullet point about interpreting and applying provisions of the district code and board policies is important because this gets to the issue that concerned Director Pearson, and I'll talk to that in a moment. But I also want to point out that there are many duties that the board can assign and prescribe to the general manager beyond just what's in the code. For example, that can include asking the general manager to attend county board of supervisors meetings to represent the district, to work with other agencies and trade associations on various matters, including legislation that can impact the district. And going back in particular to this last bullet point, Director Pearson did raise the issue of the general manager's role in addressing legal issues. This is actually a very typical duty of local water and wastewater and other utility district general managers. In fact, many agency job descriptions for general managers actually include a required skill that general managers understand legal issues and legislation, work with legal counsel and the board to adopt appropriate policies to implement those legal requirements. And in my view, none of this is an actual practice of law. In this context, what it is the GM is responsible for interpreting and communicating board-adopted policies that apply the legal mandates the district operates under and which are prepared and adopted in consultation between legal counsel, the board, and the general manager, and legal counsel's advising the general manager on a day-to-day basis when issues come up regarding application of the code and policies in terms of being able to communicate those legal concepts to constituents, applicants, et cetera, and of course to the board. And, you know, if legal counsel had to always advise on a issue that involved anything interpreting the law, it would be very expensive, it would be inefficient, and it really wouldn't be very practical. And so the whole point of having a code and policies that distill and interpret the laws that allows laypersons, including your general manager and yourselves for that matter. You often talk about legal concepts when you're in a board meeting. Having those code provisions and policies allow you to do that without engaging in unauthorized practice of law. Next slide, please. This slide just addresses legal counsel's role with the district. Again, I'm one of the board's direct reports. My job and my firm's job is to provide legal advice to the board and the general manager when requested or required. Sometimes we see things that we need to tell you about, whether you've asked for that advice or not. For example, changes in law that come along. We monitor every legislative session, bills that can impact our clients, and we actually provide a report at the end of every year on those changes in law, new laws that may impose new mandates. So that's all part and parcel of what we do. Next slide, please. And the last subject area I wanted to just talk about briefly are conflicts of interest. There are two basic conflict of interest laws. As noted on the slide, there's the Political Reform Act, which is concerned with direct effects on a director's personal financial interests. And then there's Government Code 1090, which really involves impacts from the agency's making of a contract in which a director might have a financial interest. I don't want to get real deep into conflicts tonight, but I do want to note, as the slide says, the rules are very complicated and fact-based. When a potential conflict comes up, it's always best to consult with us and for us to delve into the facts and to then apply the FPPC's regulations in the Political Reform Act to ensure that we know whether there's a conflict or not. And there's also one other category of conflicts. They aren't actual legal conflicts, but there is what we'd call a common law or perception issue. And we usually use the term, the front page test for that. And in this case, you don't necessarily have a real conflict, but your personal involvement in various matters in the community may lead people to perceive that there is a potential for a conflict, even if there isn't. And in evaluating that, you can certainly participate if you feel you should participate in a particular issue where there might be a perceived conflict, but be mindful of the front page test, which really talks about how that would look to the public if it appeared in media the morning after the meeting, and they're talking about your personal involvement in an issue and whether you'd feel comfortable with that discussion or not. Next slide. And this one just talks about PRA financial interests. I don't think we need to delve real deeply into this at this moment. So we can just move on to the next slide, please. And the last slide here, I like to give Elvis the last word in these presentations. his statement sums up the proper conduct and attitude for those who want to be elected or appointed to do public service. And final slide, please. I just want to thank the board for listening, and I'm happy now to field any questions or discussions that you have.
Well, thank you. Thank you, Josh, for doing this for us. We appreciate it. It was great presentation. I think you answered all our questions, right? Well, thank you. So let's go ahead. I'm going to go ahead and open the floor for our board's members to see if they have any questions. And please wait till you're recognized, and then you can answer your questions. So, okay, Director Lowe, please.
Thank you. So one of the questions that I have is attached to this presentation, there is the policy handbook. And under section 4048.1, it says legal counsel shall present and report on all legal issues. So I interpret that to be not just pending litigation or possible litigation, but also be inclusive of any legislative changes. Is that a fair statement?
Yes. And I don't know if Mr. Briltz presents our annual legislative report, but as I said earlier, we do issue one to all of our clients. And if the board isn't receiving those, you certainly should be, but you know, we do track legislation. We work with various trade associations, for example, ACWA, CSDA. We also actively monitor a number of bills for our clients directly, where clients have particular interests in those bills. So this is part and parcel of what we do as general counsel.
And so your review of those legal matters or legislative matters, you would then also, if there's something that you think would have an impact to the operations of the district, you point that out.
Absolutely.
Okay, and then I know, Jeff, you also get that information from CSDA in terms of legislative changes as well.
We do, we probably get kind of a legislative summary from at least 4 sources. BKS produces one, typically mostly focused on you know, water, wastewater, or special district related issues. We get one from CSDA that'll be a somewhat broader topics. We get an annual update from Lieber Cassidy Whitmore. We also have an arrangement with them that focused on labor relations or employment law issues. And then you know, we have another relationship, and I apologize, this is maybe somewhat more complicated than it ought to be, but we have another relationship with Carmel and Akasha, and they provide sort of very general legal services for the district when they're not real specific to a utility need or something that's more historic. For example, David Hirsch, who you know, he reviews our agendas every agenda, and and their firm is assisted on matters that we don't have a historic relationship with BKS on. For example, I think the last really significant matter that Carmel Natasha assisted us with was on the implementation of the franchise amendments and the solid waste code amendments relating to 1383.
So I kind of would recommend that this policy be amended to be a little more inclusive of the legislative side and not just report on legal issues. Because legal issues sounds to me like it's just strictly litigation or potential litigation, but I think it would probably be worthwhile to include legislative matters as well. So just a recommendation there.
It would be quite easy for me to just forward along these annual summaries that we get from these various sources to the board if this is something that you're interested in reading. We do monitor them as they come through. And again, what I want to caution you on though is the work that CSDA or PKS does. They're going to have a summary of maybe 24 pieces of legislation, or maybe on you know, some number of them, and many of which won't affect the district at all, because the item is written for all their clients collectively, not just for us.
Understood.
Any other questions?
Is it right now?
Great, thank you. Any other questions?
So I guess piggybacking, I'm sorry,
Yeah, go ahead, please.
piggybacking off of that, so the legislative report that's provided at the end of the year is kind of a general to all clients. But what about in situations where we need an analysis of specific policies as it relates to specific legislation?
When there's something that clearly affects a set of clients, change in water law, change in wastewater law, the Brown Act or whatever. I mean, you know, our reports are relatively brief, but they do provide some practical advice, and it always encourages specific general managers or boards to contact us if they want a more thorough analysis of a particular piece of legislation and how it can affect the district. So, you know, certainly if the board requests at any time, we can provide a more extensive analysis if the board requests that we do that. And that's simply a matter of having that presented as a board discussion item and the board approving, forwarding that request to legal counsel, and then we will act on it.
So, but that process, the best practice should be to send it or discuss it to the board, whether or not to send it to legal counsel, not necessarily to provide the legal analysis at the board level.
Well, you know, we're your lawyers, we're not anyone else's, and the advice would always come to the board if that's the request.
Wasn't her question.
So I guess I'm asking, so you kind of described the process of if we need like a specific policy kind of further analyzed based on legislation or based on your legislative report. What is the best practice? Say that the board is now discussing specific legislation. Should the best practice be to authorize counsel to do that legal analysis versus the board itself doing that legal analysis?
I understand, yeah. I mean, in the first instance, we are your lawyers and what we do for you is analyze the law and advise you on it. So yes, that would be the best practice, generally speaking.
Good for you.
Hi, Josh. I don't know if we've ever met before. Have you had an opportunity to review the correspondence from Director Pearson dated March 6, 2024?
I have.
And could you guide me to where in your presentation you specifically addressed the following comments that were raised in her correspondence? One, I believe the board's practice of interpreting law and applying it to our policies and procedures without the advice of counsel is a gross violation of California law. And second, if the board is going to address or interpret an application of any legal statute, case, or legislative acts to any of our policies, is it best practice to consult counsel? You did touch on that under the general manager's role, but we as the board sat here trying to give legal interpretation, and you did not touch upon that in your presentation.
The same principle applies. You have a code and policies that you have adopted. And my understanding is you were talking about the application of that code and those policies in a particular context. And again, I don't believe that that is legal practice. That is discussing legal
correct.
information that has already been processed through the general counsel advice process in forming your code and policies and turning that into a set of plain language policies that can be applied by the board or the general manager in the context of your operations.
I would say that was incorrect. We had people here reading Senate bills and interpreting them, not just looking at our adopted code.
Okay,
So
well,
just you, I believe that you, or my understanding is you did review those tapes. And so you did not answer my question. So I'll move on to the next one. Based on your understanding, how do the courts define legal advice? And does that include providing a legal analysis of new state legislation as it applies to our current policies?
I'm not familiar with a particular court case that defines legal advice. Other than, you know, they're state bar rules and they involve folks who hold themselves out as lawyers who are talking to a client and purporting to provide them with legal advice on a particular interpretation of a law. That's not the case. The client, you're talking to yourselves. There's no client. There's no attempt to
Our
provide
community
advice
is our
to
client.
someone.
I think what he's referring to is the attorney-client relationship.
Well, I wasn't.
Well, no, I think that's what he was.
But that is the, there has to be some intent to form an attorney-client relationship and to have somebody who's purporting to advise someone on a legal matter and holding themselves out as being skilled and knowledgeable in that area. That's not the case. I'd also point out in the board context that board members have broad immunities under Civil Code Section 47 and other laws. You're not going to be hauled up in front of the state bar or court for giving yourselves legal advice.
We were not giving ourselves legal advice. Okay, move on. Shouldn't board members avoid providing legal advice or legal interpretations to or on behalf of the district in general, and especially in a public meeting?
Again, I mean, if a board member wants to raise a legal issue and discuss it, I think that's within your purview. And if the board generally has an issue with what a director's saying, it's real simple. Send us a request to provide you with an actual legal memo or legal advice on a particular issue, and we're happy to do that. But I don't think that, you know, having that discussion amongst yourselves in a board meeting amounts to illegal legal practice.
Okay, I'm understanding your position. General Manager Brooks introduced a memo to this item on the agenda stating 2 board members raised concern about district officials other than legal counsel were interpreting law. Per the Brown Act and policy and bylaws, our policy and bylaws, shouldn't that March 6th correspondence from Director Pearson be included with the material for tonight's meeting for the public to understand the purpose of this agenda rather than having me request to have it attached? You did talk about transparency earlier in your presentation. It appears to me that if you didn't answer this correctly, you would be violating your own advice to us to be transparent.
I'm not understanding the question.
Okay, I'll repeat it.
No, ma'am,
Ma'am,
the memo is in
ma'am.
the board packet.
Director,
It's been
Vice
disclosed.
President
I'm not
Jeremy.
understanding what's untransparent about that.
My question is, by not including the correspondence.
It is included.
It was not included until I requested it to be included. So therefore, it was not transparent to the public upon the initial posting of our agenda.
May I answer that question. We were discussing that, we were trying to figure out how
Who's
to
we?
do that. It was general manager, and I, and, our attorney. The reason for it being because there may have been a personnel violation. And we wanted to make sure that the general manager, it could have been a personnel issue. So that's why we were holding on. And we
It's
did not make
amazing.
that
I
decision.
sent-
We did not make that decision till it was late evening, and we were going to announce it Monday. So we were looking at that. Because general manager's personnel rights may have been violated. But if you had just,
That's not the appearance. And I sent an email to General Manager Biltz on Sunday. He didn't post it until Monday morning.
because it's Sunday, it's
I'm,
not.
I'm happy to clarify it if this is critical. I had specifically asked, Josh whether the memo should go in the packet for a couple of reasons. He said he didn't think it should. And then late last week, Board President Fardonish asked me if this issue doesn't come up, can the memo, be, produced? So I reached out to Josh. I said, look at this again. Is it a public record? And at about 6 o'clock Friday evening, he said it should be considered a public record. And so I knew at the time that we would make it available but I also knew that if it's given to the board as a part of the agenda packet, it has to be made available to the public at the same time. So when I received the request Sunday from Vice President Giardini to forward the email, I waited until I was able to post the document to the district's website, so it was made public at the same time it was given to the majority of the board of directors.
Okay. On your slide, under ensures legal and ethical integrity and maintains accountability, is it advisable that individual board members analyze our contract agreements such as cell towers, easement procurements, or Senate bills and make a legal determination without consulting counsel?
I think any director has a right to look into something. Ultimately, that should come to the general manager and legal counsel after it's been to the board. If that's the sense of the board that it's something that needs to be pursued, then it should be pursued.
So you're stating that when a legal determination needs to be made, that we are not to make it, that actually you're to make it, our legal counsel.
I think it should be made on legal counsel's advice. Yes, absolutely.
Okay, so I would agree with that. Should we ascertain that we are confident that our code is compliant without consulting legal counsel or relying on an internal memo providing proper analysis?
Are we referring to the ADU issue, Director Giardini?
I'm referring to any issue.
Oh, well, oftentimes issues come to me and I advise the general manager, who in turn advises you. So, for example, in that situation, that's exactly what happened. We have been tracking that legislation every year regarding this. And as I advised Mr. Briltz, and he in turn advised you, there has been nothing since 2021 that has impacted the district's code and its application of ADU entitlements. Everything that's happened since then has been in regard to land use authority, as one example.
Okay, so you brought up the ADU ordinance.
Please.
If a board member questions the legality of our code or policy, and the board was not provided evidence that the code or policy was compliant with current state law, would you recommend that we ascertain legal counsel to review the item?
If the board agrees that that should be done, it should be done, but
So
that assumes there's anything to be reviewed and that the general manager hasn't already discussed that with me and I haven't given him that legal advice, that there's no basis to pursue it. And again, we know what we're talking about here. That discussion was had. The advice was given through the general manager, and the board decided that there was no need to pursue it.
Okay, you keep going back to the ADU. I'm speaking in general terms here, okay? Because
it would-
what you're
Again,
saying.
It would depend on what the issue is and how it's raised. If it comes to the
in
general
other
manager
words-
to me, I'm gonna respond to him and he will convey that to the board. If there's,
if we-
the board's uncomfortable and needs to pursue further legal analysis, you can request it.
Our board was not provided evidence. We had no evidence that our policy was current. And by your answer, you're saying that therefore, we don't need to go to you to make sure of it current. That's how I read your answer. I'll move on to the next question. Does our role as directors allow us to interpret, analyze, and advise the district regarding state law and compliance with state law?
It's been asked and answered.
Please answer it again.
No, I don't need to answer it again. You've already been advised. Directors have broad authority to come into the boardroom and say what they think. And if the board feels that there's a reason to pursue that, they can ask us to do further analysis and provide a report back to the board on that issue.
You're saying we have broad authority to discuss things. You didn't answer my question about ability to interpret, analyze, and advise the district on state law and compliance with state law. That is different than a discussion. I'm saying, do we as board members have the right to interpret, analyze, and advise the district regarding state laws? I'll move on to the next question. I believe your silence answers it all. Regarding general manager's role on page 10, does this allow our general manager to assign a policy to be authored by staff without the review of legal counsel? And hypothetically speaking, if that is to happen, should the general manager know which staff authored the policy, if the policy was referred to legal counsel for review, and if there exists a proper paper trail legitimizing the policy's determination?
I'm not following the question.
Okay, I'll repeat it. Under general manager's role on page 10 of your slide, or page 10 of your slide, you have that the general manager's role interprets and applies provisions of the district code and board policies. My question to you is, does this allow our general manager to assign a policy to be authored by staff without the review of legal counsel? Let's start there.
If it's interpreting an existing code provision that's already been reviewed by legal counsel and to apply that provision, I'm not understanding why it's further advice of legal counsel.
If it was interpreting state law and application of state law.
That's what your codes and policies do. That's the whole purpose. Again,
Correct, but she
they're
was
to
offering.
it's to put them into layperson's language so that your staff and yourselves can discuss and apply those policies.
Okay, she was authoring a memo.
Who's she?
Listen, Tina Myers, our civil engineer, former civil engineer, and she put into a memo what she interpreted state law to state. And when we asked the general manager if that memo had been reviewed by counsel, he did not know. And he also did not know if there was a paper trail legitimizing the policy's determination. So my question back to you again is, does that allow our general manager to assign a policy to be authored by staff without the review of legal counsel? And I'm talking about not taking our code, interpreting it, but taking state law, and making it into our code.
Uh,
So if I can interject for just a moment, if you don't mind, I think
Just wait, please. Let,
I was waiting for her to respond.
Go ahead, please.
I think I've dumbfounded him again. We'll move on to page 11.
Well, I was.
No,
just-
you haven't dumbfounded me. You know, you're creating hypotheticals that are incorrect, and this isn't even hypothetical. It's real.
That is not a
I've seen the
hypothetical.
I've seen the memo. It was interpreting your code and providing that advice based on your code. It wasn't an interpretation of state law at all, as I understood it.
You are on record, you realize, when you're saying this.
Whatever.
Next question. Under your page 11, under general counsel role, provides legal advice to the board and general manager as requested or required. Are you required as our legal counsel to inform us when our codes may be out of date?
Yes.
Okay, I have a follow-up question on that. We had a situation come before us because you earlier said that you track state law and that you inform us when it changed. We had a situation come before this board where our code was not compliant with state law. Not only did we have to grant a modification that night, but we also had to then approve a change in our code. So you are incorrect in stating that you keep our codes up to date, because our code was out of date and it was improper and it was illegal at that time. And
I have
that came
no
before
idea
our
what you're
board.
referring to.
Okay, I'll tell you. I'm surprised you don't know. We had an accessory dwelling unit come in, and the requirement in our code said that they had to extend the public utilities line. That is against the ADU code. You cannot be required to extend public utilities. When, I don't know who discovered it, but when it came to our board, when I believe the person who was doing the ADU probably hired an attorney to look at it, was brought to our attention that our code was wrong. So we had to grant them a modification that night because our code had not been updated, and then update our code. So your claim that you keep us informed and you keep our codes up to date and you constantly review them and keep us.
No, we don't constantly review them. I never said that. Don't put words in my mouth. So
You did
that's
you
wrong.
did
We
assure us.
we inform the general manager about changes in law, and that's available to you as well. And if there's a need to review and update your code, it's incumbent on the board and the general manager to ask us to do that. We don't have plenary authority to go and update your codes without your permission and expend your resources.
You stated in your presentation to us tonight that you keep up on codes.
Yes,
and
we
that
do.
you would- Right, and in that case, you failed.
Well, I don't know the situation, and you are making a very broad statement about the ADU law that's incorrect. There are many cases when extensions can be required.
Have you read? I won't go there. I can say that we were forced to grant a modification so that we would
Fine.
not be.
You know what?
illegal, and that our.
The
code
five
had
of
to
you
be
are
in-
welcome to have a discussion and then review us and fire us if you want.
May I say, who determines
How many? Two?
do not step on or squash my ability?
I'm not,
Two.
because there are other board members
Ah,
that will
I have
ask questions.
I have
I
one more,
understand,
yeah.
I just wanna know so that way we all, be
10 to 15 more minutes.
thank you.
Okay, who determines if a cell site contract, an easement, procurement, or a Senate bill has a policy implication that the board needs to discuss separate from adoption of the code? And how is that policy versus legal aspect presented to our general manager and our board?
I'm not following your question. It's compound and vague, and please ask me a question that's understandable.
Oh, I'm sorry, I'll try to dumb it down. Okay, is it council's duty to inform the general manager on board that a policy does not comply with the new law?
When we're aware of it, yes.
Thought you told me that you kept up on those things. Is the general manager allowed,
Please.
hey, he's not being nice
He's
to me,
answering this. He's answering.
and I'm
Yes,
being,
yes, yes. I will take the floor away from you if you do not show respect.
okay,
I'll ask you, I ask you to treat everyone with respect, gentleness, and kindness. That's what we're required to do.
okay,
So
could you
please.
ask them and if him too?
He's.
He
has
called
done
me
it.
ma'am, and if you notice
Please.
in his report, he referred to men. Nearly all men.
Just, it's our duty. Let's just stick to our own behavior, please.
Okay.
Thank you.
Is the general manager allowed to have staff interpret codes and policies without vetting their interpretation before legal counsel or the board? Please explain.
Please repeat the question.
Is the general manager allowed to have staff interpret codes and policies without vetting their interpretation before legal counsel or the board?
Policies, again, policies have already been vetted, and staff's job is to interpret them and apply them.
Conflict of interest. I was wondering why that slide was in there. Are you stating that if our board opts not to have codes and policies reviewed by legal counsel, then we have a conflict with our bylaws?
No,
Okay. This issue was not raised at the February 20th or March 5th hearing, so why was it included in your presentation tonight?
because conflicts are part of board governance, and it's important to touch on that as part of a board governance discussion.
Okay, at the March 5th board meeting, the issue was raised that board members were interpreting the law as stated in General Manager Brilt's background summary. Every bill has an enacting clause, and there's organizational features in a bill. Organizational features do not usually do not contain the bill's legally operative language, and that's why by themselves they create legal rights or prohibit conduct or impose penalties. They do not. But a court of legal practitioners interpreting the statute may look to these contextual elements to resolve an ambiguous provision that is substantive. In the Supreme Court's words, headings and titles are tools available for the resolution of a doubt about a statute's meaning. So hypothetically speaking, is it correct to acknowledge that when a lawsuit is undertaken, the intent of the bill is a factor used to determine the legality of the suit? On the face of the bill, the intent.
A lawsuit's different from a law. I'm not quite understanding your question.
I'll repeat it.
No,
Is it
I don't need to hear the whole thing again. You're conflating two separate issues. The context, the legislative intent language that you're referring to involves an interpretation of the law. It has nothing to do with filing of a lawsuit.
So in the ADU law, the intent of the law is to make the housing more, or make the housing less expensive, to
Okay.
make it more.
No, look, let's cut to the chase. You're a special district governed by Prop 218 and Prop 26, okay? The legislature can't change that, and they didn't attempt to because they allowed special districts that provide utility services to require connections and connection fees in many cases, as your policies and code permit. And if you don't, you're subsidizing development and your ratepayers who have already paid their own way are paying for that development. So there's a tension here that has to be resolved. And the legislature attempted to, and our advice is consistent with that. So you don't wind up with a bigger problem on your hands because your ratepayers are subsidizing new development.
I don't believe you answered my question. But we'll move on since you weren't able to answer it.
Okay. Mr. President, excuse me.
Policy.
I didn't come here to be grilled for half an hour on these issues. Can we move on at this point, or am I gonna sit here for another 20 minutes?
No,
I
I
think
have
we have
three
time.
more, I have
Got
three
three-
more questions.
3 more questions.
And please understand that I'm asking you not to squash my First Amendment right to ask questions during a board hearing. I can go on as long as I want.
Actually, that's not true. The board president controls the meeting, and even directors can be asked to cut it short.
Okay, I'll grant you that. It will show up other ways though. So our policy handbook, it states that 1055.4 advocacy priorities prevent restrictive one-size-fits-all public work requirements that increase cost to taxpayers and reduces local flexibility. Also, our mission statement says, regarding our mission statement and our policy handbook, our mission statement says to provide the community with water, sewer, fire, parks and recreation, refuse, lighting and drainage services with the highest possible degree of cost effectiveness, efficiency and customer service. So regarding our mission statement and our policy handbook, are we in violation of our mission statement and adopted policies if we are imposing the costliest option? And are we violating law and leaving the board vulnerable to legal challenges?
I can't analyze and answer that question right now.
Okay.
I'm not familiar with what you're referring to.
Seemed like a straightforward answer to me. But I think my last question is, could you please define the difference between legal advice and interpretation and legal information for the record?
I'm not prepared to do that at this time.
Where's your lawsuit to do that? Thank you. That's inappropriate.
I have like one follow-up question that was brought up.
Go ahead.
You mentioned earlier that, I'm sorry, were you aware of any state code or case law regarding the definition of legal advice? You said just the state bar, you were familiar with the state bar's kind of
Mhm.
position on practicing. There's actually 2 case laws and court cases as well as the professional and business code that defines legal advice and practicing. And I only bring that up because my email was pertaining to just the portion of legal advice. It had nothing to do with exploring our ordinances or interpreting our ordinances or providing memos regarding already established ordinances. My concern was a state legislative statute was presented to our board, and members of the board went around and essentially recited that state statute and applied it to a specific set of facts and policies. And I understand that there is kind of a leeway to provide opinions as boards regarding our ordinances and our laws, but when does that opinion cross the threshold to legal advice? And based on the court cases, that is the concern of, was that threshold crossed at that board meeting? And that's kind of the background of my email and the purpose of my email and my concern regarding the legal advice.
Okay, you know, again, the board has a right to talk to each other and to say things under Civil Code Section 47 and other laws that stays essentially within the boardroom. And I don't know, when you're talking to each other and talking about these issues, and again, you had a discussion, should we send this to legal counsel? You could have done that. We could have provided you with legal, you know, actual legal advice on an issue if you wanted to have that. But having that discussion amongst yourselves, I don't know how that amounts to legal practice.
Well, it's not necessarily legal practice versus legal advice, and court cases distinguish between those two and different types of activities. Regardless, you say discussion amongst us, but the meeting it's a public meeting, public members can attend. Public members can essentially take what has been discussed at this recorded meeting and take it back to whatever and implement whatever, if they're working on a contract or development, and say, this is the position of this board. This is their legal stance. So it's not I don't understand this talking amongst each other when it's a public setting.
I'm,
I have one more comment. Her point is exactly my point. Difference between legal advice, interpreting the law, and legal information. And that's what I asked about consistently in all my questions.
I have never in 24 years of boards and general managers talking about laws and interpreting them and applying them within the context of your codes and policies as legal advice or legal practice. I'm just not understanding the concern here.
Director
So,
Williams?
so I guess I think what I'm hearing is the concern is that, are we doing ourselves a disservice by not using and relying upon legal counsel when there's changes in the legislation? And I think the instance that came up was the memorandum from Tina Mayer, who's no longer here, who basically gave her opinion in terms of what the impact was on some legislative changes. Is that correct? I mean, in terms of how it impacted the district's code.
Actually, the memo was written to help the public interpret the district's code, because even the code itself is somewhat complicated.
So it's interpretation of the code.
Yes.
And so I think the concern that I'm hearing is that appropriate, and the board relied upon that? And correct me if I'm wrong, your concern is the board's reliance upon that appropriate? Should the board not seek legal counsel to ensure that that interpretation is in fact correct? Is that a fair statement?
Kind of, but let me add on a little
Okay.
bit. It's not the interpretation of our ordinances and policies, because that's within the scope and duty
Yeah.
of the employees. It's the discussion of state legislation, outside law, other legal sources to the application of our ordinance. It's that process. The internal memo, there's no issue with that, other than it didn't really reference the legislation that was being brought up, so it was a little outdated.
Okay.
But the issue is the state law, the analysis of the state law, the state requirements, the legislative acts to a specific set of
Any
policies.
possible legislation subsequent to the
Right.
date of that
Right.
memo? That was your concern?
Right.
Okay, and I think going back to that night, because I listened to the recording a second time, much to my boredom, but because I think that discussion was convoluted. I mean, the discussion itself focused on two things. One is legislative changes, and have we had all the legislative changes of recent reviewed to see if it was applicable to the district's code, and was there a necessity for a change in code? And I think that's what you were pushing for. But there was also a discussion about policy changes, in that our code is not friendly enough to the public. And I think with the intent of the state trying to promote ADUs as a way of addressing housing and the shortage of housing. And so I think the discussion got a little convoluted. And I think, and quite frankly, I was on Zoom that night and I was deathly ill. And trying to follow all the discussion, but I think that in itself has caused, I think, where we're at now with a lot of disagreement, and I think, in my opinion, and correct me if I'm wrong, but it's the board's discretion whether or not there's a need for issues to be forwarded to legal counsel. I mean, the general manager has an obligation to say to the board, I think we need legal counsel on this, or to advise the board that legal counsel is needed. I think it's a two-way street. I don't think that there should just be a reliance upon one source. Jeff Brilitz and your staff are closest to the code in daily operations. And you guys know how that policy in the code is being applied. So, and I go by based on my own career and professional, when I was a vice president of operations in a publicly traded healthcare organization, it was my obligation to know what changes were happening in regulations to say, what was the impact on operations? And I view it similar here, is you've got to know what's the impact. I think when we have code changes, legal is reviewing that code changes, but some of that is a two-way street. It's legal counsel I'm hearing is reviewing it for possible impact to the district. But my expectation is also that as a general manager, you're doing the same and looking and keeping an eye out for what are those code changes. Then it comes to the board, and it's the board's discretion to a certain extent and being advised of the general manager. I think your concern is I think based upon the last discussion, were we being short-sighted in not addressing some of those possible changes subsequent to the date of Tina's memo?
Well, I think we just kind of missed a few steps, or there wasn't a communication that maybe council had already reviewed that legislation and had kind of given a general like blurb about it. You know, and my concern also comes from my own personal career too. I am a licensed attorney. And so, you know, it does alert to me, and, you know, it was just a really gray area. And I'm, you know, was concerned that the threshold may have been crossed to legal advice because it was a public meeting. And so that's the concern that I had there. Regardless of the policy that was at issue, like you said, it was essentially two different subject matters that got blended into one. And my concern is solely on how we approached the legal analysis and the advice and kind of that area of it.
So some of it I think is also kind of a trust factor with all of us, because being on a board is so different than being in an organization where you have a hierarchy. We have really, none of us have a reporting relationship with one another. We're peers. And I think that we're going to have issues come up where we're not going to agree. But I think that if there's something that your vote is a dissenting vote, I think if you feel strongly enough about it, perhaps, and you may have felt that maybe we didn't give it proper consideration. But I think it's incumbent upon us to go to the general manager and say, hey, I feel really strongly about this, and I feel this is, you know, how I think it just needs to come back before the board, or help me understand this. I think it's part of the communication. And I think we have to have that open communication with one another, going through the general manager, of course. But I think if there's something that we feel that strongly about, I think it's a discussion with the general manager. And maybe the general manager engages us with legal counsel to discuss it further. But I think we can avoid where we're at today, because this is not, I think, healthy for our board. And so, you know, hopefully we can overcome this and go forward. But I would have not liked to see your memo made public because two reasons. One is that it's kind of like it's a dissenting opinion of a vote that was taken by this board, where the board overruled the decision. It's my perception. The other is that I think it also, the general manager, you know, it's kind of saying, you're not doing your job. And I think as a general manager, I think we're very fortunate to have you. And I appreciate what you and your staff do. And I just think that, I'm not sure that it served any benefit for all board members to see this. I think it would have been better for a discussion between you and the general manager to see how can it get resolved to your satisfaction, and then perhaps even have the issue come back to the board without looking at policy changes, but just looking at legislative changes and a review of our code from Tina's memo, that dated that memo, and forward to the current. So,
I just want to, I hate to, I don't want to derail this in any way. The issue of having items revisited, this is a very specific, this issue of reconsideration is a very specific, it's a very specific item that does come before boards. And, there's a formal way of going about it, and it has happened here once since I've been here. Under Rosenberg's rules of order anyway, a motion to reconsider should be brought by a party who is initially in favor of the item. You can, if we allow items to come back continuously because a person who voted in the minority can bring an item up every single time, you could have this item, and I'm not speaking of this particular issue, but in general, you could have the same item come before you every single meeting and get nowhere.
and I don't expect that, but I think you were very passionate about what your opinion was on this issue. It was certainly
Well, so
enough
let's,
to.
let's separate the issue here, though. I'm not passionate about the policy and
No,
the
no, no, no,
specific-
not the policy.
I, within my profession, but also within my duty as a director, I had an issue as to an ethical and legal issue. And I raised it directly to our general manager, and these steps were taken as a result. But this isn't about me having a dissenting opinion. This isn't about me having, this was me having a concern about the way we're handling legal and an ethical concern.
Yeah.
And I raised it to the director. So I don't want to get that
Okay, okay. thank you for
convoluted
that.
again.
Yeah.
It's completely separate.
Okay,
My vote was shot down. I respect the vote. This is the democracy. My issue was that within that discussion, I had an ethical concern about the discussion in the realm of the legal discussion going from opinions of members to the threshold of legal advice. So that was my concern, and that's what that email is about. It has nothing to do with,
Do you still have that concern?
I do.
Okay, so what can we do is for, so that way we could.
I
because
think
wanna
it's been a
move
good
on from this.
discussion that we have now been made aware that council every year kind of provides a summary. Maybe some guidance to our general manager is highlight some major ones or some that may directly impact and give us like a brief summary at the end of the year or when you receive that report, just so that we know there's like a communication chain happening or.
Actually, that's a really easy read. I could just forward it's a few pages. It's not that difficult.
So from.
I just want to know that legal counsel is being consulted at some point in the process when we're discussing
well, I
state
think it would be
legislation.
beneficial if we receive the whole thing,
Yeah.
because
So-
it's another set of eyes to look at it, and it's certainly if there's questions that come up, and certainly sometimes we receive questions from the public as well. So I think it would serve to the board's benefit to have a copy of that.
So from your email, I saw that there were two big concerns. One was your professional license. So, I mean, I wanna ask the general counsel, does Director Pearson, should she have any concern about her professional license being at stake
It's
based?
up to the state board of
Well,
county.
I mean,
He can't advise me on my.
Well, no, but I mean, we should know that. I mean, we should know that as a board.
If
Well,
there's
as
a
an attorney,
concern,
you should
legal,
know. Yeah, so-
I should know, yeah, that's my
But-
own personal, he can't advise me on my own personal license.
Well, no, I mean, he's our legal, he's a.
He can advise you as a
counsel.
district, but he's not my personal counsel. He can't give me personal
Okay.
individualized.
Alright, so the other concern is that, you mentioned in your email that both the board and the general manager could be liable for criminal and civil liability. Is that true? Are we gonna be
If
based on?
found giving legal advice.
Well, based on what you saw that night on the video of what happened, are any of us in jeopardy of any criminal or civil liability? And if so,
If
I'd like to
found
know,
to
so that
give
way we
legal
could.
advice.
Pardon?
But we have to be specific, if found, cause that email says the potential liability of giving legal advice without a license.
Well, so that.
So
email,
what,
I'm
what is the
assuming that
liability
email-
exposure?
So I'm assuming that email was because you thought that somebody gave legal advice
I
that
said
night.
that's a best practice, we need to consult counsel, and that this practice of giving legal advice, analyzing to code.
So you're saying we did give legal advice that night?
You took the Senate bill, you read the
Okay, you're talking
Senate,
about me, you're saying specifically me.
well, you were sitting
Well,
next to
I
this.
don't know that this conversation is productive anymore, I
Well,
think.
no, I did.
I think we
wasn't
started on a
actually
good
saying
note.
we
I
did
think-
something
I think
illegal.
we've given the general manager really good direction on how to
No, I
address
don't
this
believe that.
issue. I was concerned that there was some potential exposure to liability.
Excuse me, in
I-
your email, you said that we did something criminal or civil with it.
I did not say that.
And you're saying that I interpreted.
I will happily read my email. I said potential liability of exposure. There was no, you are going to be charged with criminal and civil. I said that it's exposing us to unnecessary liability.
But that's what I wanna know. Did we do anything that we is even
And that what we were
exposing
doing
us?
was not best practice. Those were.
Well, I wanna know that. I wanna know that. I wanna know if what we were doing was not best practice. I mean,
Well, that's up to
I
the
mean, like you mentioned, I simply read
So
something.
what it reads
from
is-
The memo that was in there, that was a public.
It reads, I'm urging you and the board to forego the practice of giving legal advice and or interpreting the law without consulting an attorney due to the potential criminal and civil liability.
Emphasis on potential. There's not, I'm not
You
saying
said,
you're
yeah,
gonna
you
be.
said like, I urge you to stop doing that. So you're
Well, no-
indicating that we did that.
I
Like urge you to stop giving advice. No, you said,
Well,
I urge you to stop giving advice, so you're saying we did that? You
I-
said
I-
that we
I
gave
concur a
advice,
little.
and
I-
our attorney says we did not give advice.
I
Well, I
disagree with
think,
your interpretation.
Josh, you had indicated that the board is protected under civil code in terms of any liability. Would that cover this particular statement that Director Pearson had put into her memo to Jeff Brills?
Yeah, it's legitimate discussion and criticism. And, you know, I truly am mystified by this whole discussion. In 24 years, no one has ever raised this issue. Boards and staffs, many of my clients have a legal affairs committee, a legislation committee. They discuss bills that are pending and newly enacted legislation. You know, boards and staffs have these discussions all the time. You're a creature of law, you're governed by laws. It's part and parcel of what you do. You know, obviously, if there's an issue that you can't agree on, or you think requires legal input, or somebody from the outside is threatening litigation or some sort of action, it's obviously best practice to have legal counsel involved, but, you know, boards and staffs do this all the time. It's what you do, and you can't adopt policies without referring to and discussing the underlying legislation. And you can, if you decided to have a legal legislation committee, have those discussions. If you
So you're
weren't
saying
able
we
to
have
do
the
those
right-
things.
So you're saying we have the right to interpret law?
In your opinion, to the extent you're comfortable doing that, you know, at the end of the day, it still has to be codified and in consultation with us, but as a board discussion matter, you can exchange your views on what things mean, and that includes legislation and statutes. I'm just, I don't
In
understand what
this
the issue is.
It was codified in our code, so we were questioning whether the code was legal or not. And we had
Okay.
people reading the Senate bill, comparing it to our code
I don't know who was doing it. You
I
were.
read a sentence, I read one couple of sentences.
directly from it, and then determined that we were in compliance with state law.
That's my opinion. There
Well-
are 4 other board members that could say no.
And
I only
so-
have 1 vote.
I think, I don't know, I feel
I
like we're
don't
going in
understand,
circles.
I don't know.
But I think it was a helpful suggestion that whatever council gives at the end of the year to share with the board so that we understand that council has reviewed, general manager has reviewed.
And
once
we know.
And we know. So I think that this is kind of a moot issue at this point and we've kind of exhausted. So I would request that we end
What
the
is, what
discussion
are
and close
they
business.
reviewing? at the
So
end of
what
the
we're-
year? I'm
The end of
asking
the year,
Director Claire.
Josh will provide the list of legislative changes, which is already going to Jeff Briltz. It will also come to the board. So the board is
So
aware of
we
what
get the
those-
review of council that is given to the general manager. The board will now get to review that as well.
We had an instant when our, because he says this has been ongoing, we had an instant that came before our board where our code was not up to date and did not adhere to the law. And we had to take an action to request a modification and then actually update our code. And so this is correct.
Well, no,
Yes,
I don't recall it, so that's why I wanna reference, the general manager, you can.
As I recall, yes, there was,
Explain it.
there was a problem with that. But it was a minor that would only happen once every 150 years, as I recall the discussion that night.
Jeff, you're always
Yes.
good at recalling
Yeah,
everything that
I believe
happens.
what's being cited is a case that the district did make a code change in 2022 relating to, sewer connection requirements, for ADUs, or, I'm sorry, related to, in this case, if the sewer line had extended in front of the property, it would have been appropriate for the district to require the ADU to separately connect to the sewer line. But the house was built a long time ago, the house where the ADU is on, was built a long time ago, and the sewer line never went that far. And so our code said if you're gonna connect any building within X number of feet, and I can't remember if it's 200 or 400 or whatever it was, the district shall require the line to be extended. And so it didn't provide that carve out for the ADUs. And so in 2022, about 2 years and 3 months ago, you did make a code change to correct that or to make a minor amendment to deal with that particular situation.
Because our code was out of date and was not up to state
But was it
law.
out of date, or was it that we were addressing a once in a?
I think that, I mean,
I don't recall it being as a result of us not being compliant with code, so much as it was the right thing to do for the circumstances.
No, I think if we had imposed I think the position at the time was that had we imposed that code requirement, we would have been out of compliance, that requirement to impose that requirement would have been in violation of a
State law.
separate issue. And that's the advice we received from legal counsel,
In violation of what? You said a separate issue. In violation of what?
state law.
State law, in violation of state law. Our code was in violation of state law, and yet we have been assured tonight by our legal counsel that he keeps those all up to date and that he's on top of them.
That's not what I said. You put words in my mouth.
Dr. Pearson,
What I said is that we advise you on changes in the law so you can keep your codes updated. I'm not omniscient, and at the end of the day, staff needs to bring something to the board's attention that a code change needs to be made and the code needs to be amended. And it's not my job to make sure every client does that. We provide the legal advice and the background, and that's something the board and staff need to deal with individually.
Thank you. Dr. Pearson, did you have a question or comment?
No, I think it's gone around and around.
Okay.
All I can say is that I'm glad I'm not an attorney. And in my practice, and I work for the Los Angeles County Pension Fund, $80 billion. I was chief of the internal audit. And I constantly, along with every other department head, interpreted legal. I don't know what all these words mean, so I'm not even gonna try. But we constantly interpreted the laws that came down from the state, from everybody else. And we had a full staff of legal counsels that would only get involved if we wanted to go and talk to them. I'm completely happy with the way we are doing things now. We bring it to the board. the board moved on it, and I think it's just bad. We're not following best practices of the CSDA about once the board makes a decision, we all get on board and present that view to the public. And I would agree, I don't think that letter should have been published, because I think it has a negative, the way I read it and the way I think a non-attorney would read it, was accusing us and the general manager of doing something wrong. And it was tarnish his reputation and our reputation. And that's not what it is after we've discussed, we've approved it. And then we have the minority that all of a sudden send letters once they have, I just think it's a bad situation. So anyway.
Thank you very much. All right, I think we all agree, we had enough of this discussion. Well, thank you very much, Josh, for being here tonight, answering all the questions, and hopefully we'll be better next time. All right, well, thank you very much.
Thank you.
Good night.
Good night.
Good night.
Okay, general manager's report.
I do have a small number of items to update you on. One, I sent you an email on this Monday morning, but on overnight or very early in the morning, Sunday morning, another vehicle crashed through the fence at German Park. Looks like it was likely a intoxicated or under the influence driver. There were no injuries, fortunately, but there has been some property damage. We'll coordinate with the parties to try to get those issues repaired, but this is at least the third time in past several years we've had a vehicle go into through the fence in that park, in a location very close to that same spot. We did receive the draft alternatives analysis that the county has commissioned from WSC on the turnout. That's the recall that our turnout's been exposed, our Nasi Meadow turnout's been exposed. There were 4 options analyzed. The recommended option is to relocate the turnout to the Creekside site. However, it's also the most expensive alternative. So everybody, county staff and we are reviewing this rather lengthy document now, and we'll get together in a couple of weeks to review its recommendations. And then we'll, if that recommendation holds, begin working with FEMA. Again, the county really is the lead to determine if in fact funding for that is possible. There's a CSDA chapter meeting next Thursday, the 25th in San Luis Obispo. I sent you, I forwarded you the invite, I believe yesterday afternoon. If you are interested in attending, it's a lunch meeting. Lunch is provided. I don't have any details on what that lunch is. But if you're interested in attending, please let Carrie or I know by Monday. And then finally, just a couple of hours ago, we finalized the appointment of a new district engineer. Templeton resident Lori Azim, who currently works as the associate civil engineer for the city of Atascadero and has a many year background in engineering, and I think she's going to be a great fit. Really excited to have her join us. We will get some more details out to you about her background and those kinds of things, but her start date is May 13th.
Wow, great, congrats, awesome. Any questions for general manager? I have a question. Can you just clarify in terms of the water units, just exactly where we are, what happened, please?
I'm probably gonna muddy the issue.
Oh,
So, the process is unnecessarily, it's more complex than it should be, but here's how it goes. So we released 129 units. We had 4 relinquished units that were not taken by the time of the release. So we coupled those together, released 133, 129 are new. To the first 100, and I believe it was 133 requested units on the wait list. They had 10 days to notify the district as to whether or not they were accepting those units. Several of those parties had. I can't recall, I think I sent you a couple weeks ago the numbers.
yeah.
And so all those parties have until end of business tomorrow to produce a 5-year payment plan agreement and payment
Okay.
on those. To date, we've received one, or maybe did the second one come in today? Just one, only one payment plan and one payment has come in. So those parties, there's like 4 others of that initial batch that are due tomorrow.
I see.
So there's kind of like a double deadline. And then in the meantime, we've begun notifying the second group and actually now already the third group, based on either parties telling us they're not gonna accept them or the 10 days passing with no notification or request to accept. So this process is probably gonna go, I mean, I would expect it to go on for several months because of again, these double deadlines and who makes them and who doesn't and so forth and so on. We did notify everybody, well, not everybody on the wait list, but the first 20 waitlist holders back in February that we were gonna begin this process so they would hopefully get their decision-making sorted out.
The person who has turned in their work or their contract, how many did they take?
4.
4. And who's requested the most? You don't have to give me a name, but the highest request has been what?
40.
That they would accept 40?
And we need to know they'll let us know by tomorrow.
No, they're on the second group, so it's got a second set of deadlines, because we notified them later. Because
Oh,
again, not until the first group didn't notify us, were we able to then notify,
So then-
formally notify
okay,
the
so
second
they're
group. So it's
past
kind of moving.
After the 10, there was,
Yes.
I remember there were 10, so they're past that. Okay,
Yes.
all right, okay, great. Wow, that's great movement, so that's good. All right, anything else, Chair Manager?
I don't have any other items.
Okay, thank you. Committee reports, there were none, unless something didn't get, no, okay. Activity update reports, anything on finance? Any questions on finance? Public, no. Okay, anything on fire and emergency services? No, okay, utilities, any questions on that? No, okay. Directors, report and or comments, any activities that any of the directors want to share?
So I will be gone, on May, 21st, so I will not be here for our meeting on May 21st. And I've asked Director Giardini to fill in for me on May 16th, for TAG.
Okay, great, all right. And, all right, Director Peters.
I also will not be here on the 21st, or I will not be able to attend the Nacimiento Committee meeting on the 23rd. And you're the alternate, and it's 4 o'clock here.
Okay.
On
The 23rd,
May?
May.
That's such a-
Actually, I'm gonna be gone for 2+ weeks, so.
Can you text me that?
I can get you a specific.
Because my phone is home and I can't put it in. What day is that?
Thursday.
At 4?
Yeah.
Okay, because I have some standing meetings, but they're not at 4 o'clock on Thursday. I should be able to cover that.
Who should I notify that seeing as I'm president, that the vice president will have to take?
I'll take care of notifying.
Okay, appreciate that.
And then, for me, I just attended a meeting with, General Manager Brills with the, library, Melinda Reed and a couple of other volunteers and staff members there. They were just looking for a steady stream of, funding. That I guess I'm sure they're getting tired of fundraising, so
So are they getting no funding from the county?
as of, yeah.
Yes, that's
yeah,
correct.
Yeah. So, yeah, the county has even cut back some services, so they were looking for that, so, we talked about them and they were gonna continue to take their own next steps. All right, and,
I don't know. So Cambria Skate Park got approved and I know that our skate park and Melissa does activities with them and the skate parks across the county as a whole. So that's a new skate park for, I think, activities to go on when they have events and that kind of stuff. So that's exciting news for the skate park.
oh, yeah, that's great, anything for community, that's wonderful. Great, since there are no other items, so we'll go ahead and adjourn the meeting. Thank you very much.